SJC-12570, Daniel LaPlante v. Commonwealth.
Mr. Schnipper, good morning.
Good morning, Chief Justice Gants, and may it please the Court, Merritt Schnipper here on behalf of Daniel LaPlante today. I do want to begin by acknowledging the horrific nature of the facts in this case. They're horrific even in the context of homicide prosecutions, and also note our concession also in our brief that the judge would act fully within her discretion in imposing the most serious penalty permitted by law. Obviously, the issue we're raising here is what is that most serious penalty permitted by law in the context of the parole eligibility date.
What do you say that is?
Well, we say it's not 45 years.
What is it?
Well, I think that we're asking for resentencing to 30 here. If I had to proffer a number for the court to adopt, I would proffer 35. And the reason I would do that is that I would say that that gives the maximum period for retribution while still allowing a beginning parole consideration at a time when it holds out the possibility that if the defendant worked hard while in prison and actually makes parole in the first or second hearing, there's some level of potential, excuse me, to productively re-engage with the outside world.
Those last 10 years of the kicker.
Well, I think they are. I think they are both because just in an absolute time frame, the amount of time that you have is obviously both accumulating in prison and subtracting from the potential time outside of prison. And I do think it's relevant, although I don't think it's determinative, the number of years that a person who begins a life sentence in their teens can be expected to live, and as just a general statistical matter, that's into their mid-60s.
So are you making the argument that it's the equivalent of a life sentence?
I'm making the equivalent that 45 years to serve before parole eligibility is the functional equivalent of a life without parole
And that's
sentence.
based on a statistical analysis, is that right?
It's based in part on a statistical analysis. I mean, that statistical analysis is important because obviously if the same analysis showed that that same person was likely to live until 85, we would be looking at a different potential re-entry into society. Of course, that re-entry to society is very contingent on the judgment of the parole board and on the nature of the rehabilitative work that the defendant undertakes during his or her time in prison.
None of that's presented to the motion judge, is it? None of the statistical analysis is before the motion judge, right?
No, I don't believe it was.
We get to decide that question without any factual record?
Well, I'll say two things about that. So it's not a major part of my argument either. It's a few pages in my brief. I feel like I need to tee it up by giving us a rough estimate of how long juvenile lifers tend to live. So, but I think what certainly was presented to the motion judge or the resentencing judge was the fact that the contention that 45 years till parole eligibility is too long under the Diachenko rule because it does not allow for an opportunity for release that's meaningful in the constitutional sense. Now,
Right, this whole idea that at 62 you don't have a meaningful opportunity to live after that, I have no idea whether that's correct or not in terms
Well, I would
of your
invite-
statistical analysis. The only thing I saw, you have something from the U.S. Sentencing Commission, which, but again, when was that done? What year was that done?
It's about 4 years ago. I think I'm thinking 2015, but I'm going off the top of my head. It's in my table of contents.
As far as the resentencing hearing goes, I know you obviously disagree on a constitutional basis with the 45, but is it your position that the judge abused her discretion in the way she analyzed the Miller factors?
Well, it's not my...
Right?
No, no, I don't think so. I just think that...
Because she found the antisocial personality disorder and discounted the other factors.
Right, no, so I think
But
that
you have no quibble with that finding.
Right, and frankly, I don't have any quibble with her discretionary actions, including that.
Okay, that was
But I
my
feel
question.
that obviously there's many cases in which a judge's discretion, must be limited by an outside constitutional principle.
Right, and that's what I'm trying to get to.
And I think it is important for us to note, because, this case is headed towards an outer boundary. Whatever that outer boundary is determined to be under Article 26 is where this case is going to land. And the principles that we're trying to bring to the court, and I think are extremely important when the court not only thinks about this defendant's resentencing, but the precedent that this decision could set for the way other juvenile homicide offenders are sentenced going forward, is that once you set an outer limit that is close enough to the likelihood time of death of just the average person in this situation, and takes you more than 4 decades into prison just as a general matter before you're beginning to be considered for the possibility of reentry, you're going to see, if that's what the outer boundary turns out to be, many, many juvenile sentences creeping up in that direction.
And as you started your argument, given the horrific nature of this crime, this sets the outer boundary.
I mean, I think it's fair to say, I mean, there's always, obviously, you know,
Well, who knows,
the
but right.
behavior of human beings knows no bounds, but I think this is pretty close to an outer boundary. But what I also think is important to bear in mind, and this is the concern that underlay the Supreme Court's decision in Roper v. Simmons, and I think is present in Diachenko as well, is that when you're confronted with these cases at the time of sentencing, you're confronted with a set of frequently overwhelming and devastating facts. I mean, they don't have to be this bad to still be completely devastating.
Roper, of course, being a death penalty case.
Right, but the principle being that if the facts are going to always drive the sentencing decision, we're not going to be able to hold to the important constitutional rule that we're establishing, that it's only a categorical prohibition
this
that
is a
allows us to hold to this rule in certain cases.
This is a triple murder.
Yes,
right?
it is.
So that, I mean, even the cases you're citing from out of state, are there any cases where we're dealing with multiple murders where people employ this analysis, where you've got a triple murder and we've set a cap? Any state has done that yet?
I have not found that. Well, I mean, but I should say that both Iowa and Washington have said we're eliminating life without parole as well for juveniles.
Those were single murder cases, or?
Those are single, but Zuber from New Jersey, they say it applies it with multiples, but that's not a multiple case. They're just kind of talking about their application of the general principles. I mean, and I would just be completely frank to the court. The Faust case from Pennsylvania goes the other way. It says we're separately analyzing the sentences in each sentence. So they say they had 2 sentences with 30 years till parole eligibility each made consecutive. And they said each 30 is compliant. We're not going to worry about the 60. That's 2 separate sentences. I think that's a deeply, deeply weak frame of argument, because the important factor here is the nature of the offender, not the nature of the offense. I mean, that's obviously an underlying principle.
The purpose of,
Graham and
in
Miller.
your view, the purpose of the Costa remand was to see how much over 30 you would get?
No, the purpose of the Costa remand was to allow the judge to basically reconsider the consecutive sentencing decision that was originally made in a somewhat pro forma or meaningless way, and that was now going to have meaning however she chose to structure it. But it was always, as every resentencing or original sentencing happens, it had to happen within the constitutional bounds.
So as you painted for us, a decision a judge would have to make would be, if there was atrocity or cruelty involved, do I give this person 20, 30, or 35 years?
Well,
No matter how many victims.
I read, so there's 2, I'm hearing 2 questions from you.
Probably because I asked
Under the
you,
new
right.
statute, you mean?
Right, under the new statute.
And,
Yeah, walk me through a sentence.
So it would be, if you have 1 extreme atrocity or cruelty homicide under the new statute, I read it as a mandatory 30. There's no
Okay,
option to go lower.
So there's the mandatory 30, and there's a Miller hearing,
Right.
mandatory 30. Now, if there's multiple victims, the only thing the judge would do is have a hearing under your view and to see if I'm going to add 5 years of parole eligibility.
And, well, so the judge would still have the discretion to run them consecutive, but that couldn't control the parole eligibility because of
Right.
the constitutional constraints. So then there is a very interesting question there about if you don't have a separate sentence to anchor the parole eligibility decision to, can you still take parole eligibility out farther than the statutory limit that's set? I would say that there's some support going the other direction in your recent case law that a judge can, because in both Perez and Lutzkov, the court modified the parole eligibility dates down to be parallel with a juvenile homicide offender. Now, those were reductions, and they were reductions to an established point of parole eligibility from another area of law or another case, another statute. So here you would really have a situation where judges were kind of not free associating, but really just trying to figure out how much till parole eligibility is appropriate versus how far can we go before we violate the Constitution.
Okay, so say we agree with you, and we set the next time that this comes around, unfortunately, we have a Costa here, and the judge has to say whether it's consecutive or not, then the judge has the discretion, if they want it to be consecutive, to set the parole eligibility in a case involving atrocity or cruelty to either 30 or 35.
I mean, if you accepted my argument that
That's
35 was
what
the
it would lead
max.
to, right?
I think, yeah, I certainly think this court, given that we can't certainly have, trial judges independently saying, well, how many years can I add? I mean, I think some guidance from this court is needed. but
Right,
I
no,
think
I'm saying that going
that
to the
could be an
millers.
effective workaround, basically.
But no matter how many victims, that would be the discretion.
Yeah, I mean, and as I say, just like you said in Perez and Lutzkov, you can structure the actual committed sentences however you wish. And obviously, when you're consecutiving life sentences, the only thing that's really made relevant is the parole eligibility date. But you can structure them however you want, but there's going to be a constitutional limitation on parole eligibility. And I do think there's both a concern, you need to give them guidance, because there needs to, what are the factors that help determine how you simply choose some extra amount of parole eligibility, and it's not even 100% clear that works with the new sentencing statute, but I think that is a workable solution. I also think that you can decide that 45 years here does violate Diachenko without deciding that thus everybody has to go to 30. I mean, there's maybe another case out there that's going to bring up a number where the court will be squarely presented with, this is the number.
You,
This-
go ahead.
This case is different in that at the time of sentencing, at the time of the resentencing, he, I believe, was 47 years old.
Yes, or 46, yeah.
Diachenko essentially departs from the U.S. Supreme Court in saying no judge, no matter how wise, can know whether somebody is capable of being rehabilitated when they're 17, 18, 19 years old. And we have, on resentencing, allowed judges to consider all that has happened during the course of their incarceration and evaluating what the appropriate sentence is. And I think in some cases, it's helped the defendant.
Sure.
Didn't help him here. What do we do in a situation? I mean, you keep speaking as if this will apply when an individual is being sentenced at the age of 18. What consequence is there that he was sentenced here at 46 or 47?
Well, I do think it's relevant. It's relevant especially to the determination of the consecutive versus concurrent structure, right? I mean, that's what this court said in Costa. Like, that was an academic decision before. Now it's not. It may make sense for you to look at his post-conviction conduct to see whether you think it should be structured that way. While obviously that was relevant to parole eligibility, it certainly didn't say, and I don't think it's properly read, to say that now we want you to base parole eligibility determinations on your assessment of his rehabilitative progress to date. And I think that the reason that's a bad idea is that it's not the judge's capacity or expertise to assess someone's, because what she basically said, he's not ready to be paroled right now. He's just about at one of the two alternative sentencing schemes, parole dates. He was 29 years at the sentencing, so he was, if there was, two consecutive and one concurrent, he would have been eligible after one more year.
But we have said in Perez 2 that you consider the individual at the time of sentencing, you take into account all that you know. And in, I think, Perez 2,
Right.
it helped the defendant.
All right, so what I'm saying is that, let's assume she knows that she thinks that this individual needs to spend 45 years in prison before being considered for parole. That's really just simply begging the primary question that I'm asking, which is 45 years too much to serve for a juvenile homicidal offender before you pushing up against the functional equivalent of life parole bar? And I don't think the fact that you're being resentenced in the midpoint of your service of your sentence changes that fact, because either way, you're establishing an outside bar that applies. If you're going to say, well, we have a rule now where if a juvenile homicide offender comes back, has a new trial or whatever, ends up being resentenced for whatever reason midpoint through their adulthood, we're then going to set aside the Diachenko principles, and at that point, the person can get life without parole or can get the functional equivalent
Don't
of
we
life
have an
without parole.
additional complication here, which is, we now have a diagnosis of antisocial disorder, right?
Yes.
And there's some issue about whether you can make that diagnosis when someone's 17 or 18, but we have that diagnosis at 47. We also have a finding that he shows tremendous lack of empathy for the victim. So doesn't that suggest that this case may be different
It certainly
because-
suggests to me that there's going to be a very significant challenge for Mr. LaPlante to meet when he goes to the parole board.
But doesn't it also suggest that, well, we may need to keep him here until he's 62, you know?
We may need to keep him here until he fully serves his sentence, but that's a decision under law that's to be made by the parole board.
Can you explain, you mentioned in your brief that you think this is more under the lines of Roper and Graham rather than Miller. Can you
Yes.
explain that?
Sure, because both Roper and Graham, but not Miller, laid down categorical rules prohibiting particular sentences rather than allowing them to be made upon a different fact-finding procedure. And the reason I think it's so relevant to Diachenko is not obviously only because Diachenko also laid down a categorical rule, but because the rationale underlying the categorical rule was that the procedures we use cannot be trusted enough to prevent improper sentencings from happening from time to time. Whereas if we categorically bar the particular sentence, then we know effectively that it's never going to happen.
I'm trying to sort of work through the tension. I understand your view that a judge is not a parole board, but I also know that we do, are you saying that the judge here should consider only what was knowable when he was 17 or 18 and not
No,
what
I'm
has
not.
happened since?
I'm not. And
So how does a judge consider all that has occurred, take that into account, and not end up being a little bit like a parole board?
You know, they are a little bit like a parole board, but I would point the court to your decision in Diachenko 2, where you said the meaningful opportunity for release, which is what actually makes this a constitutional sentence in the first instance, is satisfied by engagement with the parole process. And I don't think anyone would suggest that this resentencing hearing was the parole process. Again, a skilled, knowledgeable decision maker, 1 instead of 7, not necessarily with all the background of the parole board. But most importantly, as I point out in my reply brief, the parole process, you don't show up for parole and then get sent back to serve 16 more years and then come back again to parole. Once you begin engaging with parole, you're either there every maximum of every 5 years or potentially, depending on how Roberio comes out, every 3 for Mr. LaPlante. And another aspect of the parole, the role that the judge plays in setting a parole date but then moving someone into the parole process later, is that when a person who committed a homicide and finds themselves in this situation, it was just 1 month later than Mr. LaPlante's, those sentences, when you have multiples, no longer, they don't aggregate. So you don't get 15 plus 15 and then you're seen at 30. First, you have to win parole from your first sentence, then you begin serving your second sentence with the minimum term. So, you know, even a delay of 5 or 10 years getting that first parole vote, and then you're only being paroled to another life sentence, you know, you can very quickly extend out past a meaningful opportunity for release. That's why I think in these juvenile homicide cases, the court basically needs to prescribe and individual judges need to impose hard dates of parole eligibility, notwithstanding the parole regulations for the constitutional purposes.
All right, thank
Thank you very much.
you. Lyons, good morning.
Morning. Good morning. May it please the court. Crystal Lyons, Assistant District Attorney for Middlesex, on behalf of the Commonwealth. I also represented the Commonwealth at the resentencing hearing, and I would just like to take a moment to acknowledge that there are many of the victims' family members in the courtroom today. In evaluating whether a sentence is cruel or unusual under Article 26, the touchstone inquiry remains proportionality, taking into consideration both the offender and the offense. The defendant bears a high burden of showing that his sentence shocks the conscience and offends fundamental notions of human dignity. This sentence, 45 years before parole eligibility, for the separate murders of a pregnant mother and her 2 young children, does not violate proportionality. The defendant's argument instead seeks to circumvent this very normal proportionality inquiry by instead elevating his status as a juvenile offender over all other circumstances. And essentially this flips Miller on its head. Miller was looking, the concern, the constitutional flaw in Miller was that there were mandatory sentencing schemes that did not allow an individualized sentencing process, nor for the court to consider the youthful offender status at all. Here, he's saying that he wants to cabin individual discretionary sentencing and say that the youthful offender status is the only relevant circumstance. And there's a similar twist when it comes to the Supreme Court and this court and Dyachenko's announcement that there needs to be some meaningful opportunity for release, to obtain release. The defendant's argument hinges on flipping that, not to say a meaningful opportunity to obtain release, but instead an opportunity to obtain meaningful release. And that is simply not the test that has been applied in the Supreme Court, and it's not what this court has applied in Dyachenko, or Dyachenko 2. Instead, what that opportunity for meaningful opportunity for release is a procedural requirement.
I'm trying to understand exactly, so if the judge is sentenced, if there were 10 murders, and the judge had sentenced the person to 150 years, how does that work?
So, Your Honor, I think that sentencing is always going to be an individual.
Trying to understand, is there a cap?
There are two ways that it can be approached. So there's always going to be an individual sentencing in which, after applying the Miller factors, or the Costa factors, or this court's test in Perez 2, in a finding of extraordinary circumstances, the judge will decide whether to do concurrent or consecutive. At that point, when we get to such a lengthy term, which I presume would not be the case in the vast majority of circumstances, because this case alone with a triple homicide is incredibly rare, and you can imagine even in other cases where there's multiple victims, it may arise out of a single incident. For example, a defendant crashing his vehicle into a family or something like that, where there are multiple individuals deceased but one incident. This one is a finding of separate incidences.
Well,
But at that-
we have examples.
Right.
Arizona, he's bringing a gun into the movie theater, so.
Right, and so, Your Honor, I think in that case, the court has two decisions. One is to look at Dyachenko and say it is a categorical ban on juvenile life without parole, so that we do have to look at the functional equivalent, as my brother is arguing, and set some term of years that we create as the outer boundary. The other decision that this court can make, or in those circumstances, would be to say Dyachenko was looking at an individual homicide. And if we look, and does not apply to consecutive sentences or multiple homicides, and that where each individual sentence is constitutionally valid, we're not going to apply the limitation in Dyachenko to consecutive sentences for homicides. So the court has really two options on where to go with that. I do believe that, as my brother has indicated, this case is rare. It is probably unique in the Commonwealth right now. But as human nature goes, the situations could arise again.
Can you address Attorney Schnipper's argument, sorry about that, regarding Graham and the Roper cases and how that's different and where we're at here?
Yes, Your Honor. I think that my brother's desire to say that we're more in a Graham position is flawed for two reasons. First, Graham was also really looking at the fact that it was not a murder case, and so it was looking at a lessened culpability, a double lessened culpability in that case. First, because of the juvenile characteristics, and second, because there was no intent to kill. Where we are in Miller and Dyachenko, there is an intent to kill, there is a loss of life, so that needs to be taken separately. But secondly, a lot of the animating concerns in Graham about the need to cabin judicial discretion because otherwise they wouldn't, there might be judges that are tempted to apply a maximum sentence, or that juveniles, for example, are prejudiced in their defense because they can't cooperate with their attorney in the same way. Miller looked at those types of flaws, those types of concerns, and specifically tailored the Miller factors to address those concerns. And this court, in Dyachenko and in Perez 2, has required that a court apply those Miller factors, and in Perez 2 has said there is a right of appeal. If the court, because they are required legal factors to apply in sentencing, if that is done in an improper way, that decision can be appealed. And so I think under Perez 2, where we're at, the considerations that were the concerns that were animating Graham are no longer present.
I'm going to read you what I think to be the most important sentence in Diachenko 1, which is, simply put, because the brain of a juvenile is not fully developed, either structurally or functionally, by the age of 18, a judge cannot find with confidence that a particular individual at that point in time is irretrievably depraved. Here, the person is being sentenced not at 18, but at 46 or 47. Does our decision here govern what necessarily should be the law for somebody who indeed is being sentenced at 18?
I think, Your Honor, like Justice Kafker's question, this court could go in two ways with that. I do think.
I know we can go many ways, but what do you,
Right.
where do you suggest we should go?
I do think that you have to take into consideration that this is a differently presented situation where it was, Mr. LaPlante was being sentenced well into adulthood, and there is that finding of antisocial personality disorder, which is very concerning. The court can choose to apply a different rule in cases where somebody is being sentenced at age 17 or 18. I don't think that that's necessarily needs to be, and I think the court should also be mindful that while we think of the typical murder case arising very quickly, and so that a sentencing is occurring at 17 or 18, that's not always the case. So, for example, like the Commonwealth has cited in our brief, the Commonwealth versus Shelley case that this court considered just a few years ago, was a case where the individual committed the murder in 1969 at age 17, but was not charged with it until 2013 when he was 61 years old. Not every case is charged close in time. So there can be situations like that where the crime is solved much later, or even an individual who's serving a current period of incarceration that is then linked to other murders. And so whatever rule this court fashions needs to consider that, not just in the context of the time of sentencing, but also where my brother is arguing for a more substantive rights under meaningful release of what that's going to look like for different individuals based on when they're sentenced. If somebody is sentenced at age 63 for a crime committed when they're a juvenile, they've arguably already had a meaningful opportunity at life, one that was not provided to their victims. And so it shows the impracticality of imbibing this meaningful opportunity language with any substantive component as to a particular percentage of life or quality of life that must be provided.
Oh, so is there a constitutional limit?
Is there a constitutional limit? I think that, as I addressed Justice Kafker, if this court looks at Diachenko and decides that we were making a categorical decision for all juvenile offenders, regardless of the number of offenses or whether it's a consecutive term, then yes, this court will need to come to some decision as to what that outer boundary is.
I'm asking you
Yeah.
whether or not
I do not
you
think that
believe
it's-
constitutionally there is some limit where, for conduct, no matter how abhorrent, and we all, I'm sure, agree that this is about as abhorrent as we see, and we see much, whether there's any constitutional limit beyond which it becomes cruel and unusual.
Your Honor, I think that for consecutive sentences that are looked at for multiple homicides, that those can be looked at independently. However, I do think that if this court were still inclined to say that we do need to look at that outer boundary for a functional equivalent of a life without parole sentence, it would be a term beyond 45 years. I don't think that at 62 years that can really be considered beyond somebody's natural lifespan.
What do we make of the fact that we have no record on what the lifespan of a incarcerated youth is? I mean, what do we do with that? So, I mean, we don't get to sort of make these numbers up out of thin air, do we? So what do we do with that?
Your Honor, you are right that that information was not presented at the resentencing hearing. I think several courts have said that that kind of statistical information is troubling in and of its own because of the discrimination that can come into that in doing a truly individualized sentence based on different statistics on gender and race and lots of other things that are involved in that.
Another way, too. It's that, and you referred to Shelley, the defendant is being sentenced at 46 and has a different life expectancy when he's 46 than he did when he was 17. So there's all sorts of layers of complexity as to what's a meaningful opportunity for parole.
Yes, Your Honor, which is why I'm saying that as the Supreme Court and this court have applied it, that is a procedural requirement, that there needs to be an individualized consideration and application of the Miller factors, whether that is at a sentencing or at a parole hearing, and to try to put meaningful release behind it does raise all kinds of those impracticalities as far as there's no guarantee of release, which this court and the Supreme Court has said many times. There's no guarantee to any quality of fulfillment of life for anybody's life, incarcerated or not. And as we discussed, the problem that sentencing is going to occur at different points in time for different individuals, and so you really would need to have an individualized actuarial determination on that individual at that point of time, which seems to me beyond what can be requested in, say, for example, a 15E sentencing evaluation.
Could you tell me how many cases there are like this out there? I don't mean in terms of multiple murders, but I mean of people who are going to be resentenced under Costa? You know what I'm asking?
Yeah, as far as in the Commonwealth?
Yeah. I mean, what are we doing this for? I mean, is it going to be for a lot of people or just a few people?
Your Honor, my understanding is it's just a few, but I can't give you the exact number.
I think it's in the CPCS letter. But,
Yes? Okay.
so your position, as far as I understand it, is that we should not apply Diachenko to consecutive murderers, but failing that, whatever that number is, 45 is reasonable in this case.
Yes, Your Honor, I do believe that 45 years is reasonable in this case, and I think if we apply the extraordinary circumstances test that this court's outlined in Perez, I don't think my brother even questions that that has been met. There's no allegations of abuse of discretion or the improper consideration.
Judge Kasanjian also clearly understood, before Perez too, I think, that the criminal conduct alone could not be dispositive. And she took into account the age as well at the time of offense and made a determination that age was not really the determining factor.
Yes, and so to your point, and to Justice Lenk, to your question, the Commonwealth is not aware of any case that has addressed this kind of situation where an individual has been resentenced in adulthood for multiple murders, where there's been an application, full Miller hearing, and consecutive sentences, and a finding that these juvenile characteristics did not play a role in the offense. So as far as that particular circumstance, this case is unique as far as the Commonwealth's research shows in any court.
And that he has an antisocial disorder.
Right. Yes, Your Honor. And I think that to address my brother's point a little in concern about the judge looking at the possibility of rehabilitation, I'd say that that is something that this court has endorsed as recently as this year in the Plasty decision, that it's a proper sentencing determination. It's one of the four sentencing determinations that's in Goodwin. It's one of the Miller factors. It was reiterated in Costa. It's part of the test in Perez. So I think that that's something that we ask judges to do every day and was reasonably applied in this case.
And is there a tension between allowing a judge to do that and having the judge serve as a quasi-parole board?
Your Honor, I don't believe that there is, and if you look to other states, even like California, for example, so, some of those states have legislatively permitted this exact function of allowing a juvenile who was sentenced as a juvenile to, after a certain point of time, ask for a resentencing hearing. And so I don't think that that intruded at all. And interestingly enough, in Okoro, this court was looking at the exact opposite, where the defendant was saying it should not go to a parole board. I should get the full Miller application at a sentencing hearing. And so I don't think that it impinges at all. I do believe that that is something that we have historically and continue to ask judges to look at.
All right, thank you.
Thank you.
All rise.